A Boston police officer found dead in the snow, and his girlfriend, Karen Reed, accused of his murder. But what if the evidence doesn't tell the whole story? Welcome to Law and People, where we uncover the truth behind America's most gripping cases. Tonight, we're going to delve into the Karen Reed case, raising questions about justice, not just in Massachusetts, but across the entire country. As new details emerge in her 2025 retrial, one question looms large. Is this case proof the system works, or evidence that it's failing us? Boston police officer John O'Keefe, a dedicated public servant, was found dead on January 29, 2022. His girlfriend Karen Reed faces charges of second-degree murder, manslaughter, and leaving the scene of a deadly collision. Prosecutors say that she struck O'Keefe with her SUV, while the defence says she's innocent and the investigation was simply flawed. What do you think? Share your thoughts in the comments section below. The 2022 grand jury indictment relied on multiple pieces of evidence, including forensic findings, witness testimony, and Reed's alleged statements at the scene. For example, prosecutors point to taillight fragments found near O'Keefe's body, which they say matched damage to Reed's SUV, and statements Reed allegedly made, such as, "I hit him," as reported by others. The defence, however, has challenged the reliability of some of this testimony. For example, one key witness, Kerry Roberts, who was a close friend of O'Keefe and who was also with Reed and Jennifer McCabe the morning O'Keefe was found. She testified in 2022 that she heard Reed ask McCabe to Google hypothermia. This was when they were standing near a police car as paramedics attended to O'Keefe in the snow. But in the 2025 retrial, Roberts admitted under cross-examination that she did not hear Reed make that request. And this is an unsettling admission, as it raises questions about parts of the grand jury evidence, although prosecutors argue evidence that was presented to the grand jury, like forensic matches, still supports their case. I want you to imagine this. If you're on trial for something and then suddenly one of the witnesses' testimony changes during the trial, how would you feel? There is an important point here because both sides agree on one point. No one witnessed Reed strike O'Keefe with her SUV or saw her drive erratically that night. Now, the justice system relies very heavily on evidence, and evidence that holds up to scrutiny, and that's whether it's direct or indirect. This case is largely built on circumstantial or indirect evidence. This means that the prosecution's case hinges on circumstantial evidence like taillight fragments and Reed's statements, which they say all point to her guilt. The defence, of course, argues that the evidence is open to interpretation and does not prove Reed's responsibility beyond a reasonable doubt. The defence also claims that the grand jury was misled by testimony about Reed's character that wasn't directly tied to the events of that night. They argue that this distracts from the lack of direct evidence, although the grand jury secrecy makes it very hard to confirm the extent of this testimony. Circumstantial evidence, of course, can be very powerful, but must lead to logical conclusions without reasonable doubt. For example, the prosecution's forensic evidence suggests a collision, while the defence points to inconsistencies, like possibly O'Keefe's injuries coming from another source, other than being hit by an SUV. What do you think? Do you think circumstantial evidence needs to hold up in court? Share your thoughts below in the comments section. I would love to hear from you. The defence also raised further concerns about potential conflicts of interest. Lead investigator Trooper Michael Proctor reportedly had ties to the Albert family, who were at home where O'Keefe was found. These allegations, echoed on some media platforms and on X, suggest bias in the investigation, though it's unclear if these ties were disclosed to the grand jury due to its confidentiality. The defence also points to the medical examiner's report, which lists O'Keefe's cause of death as blunt force injuries and hypothermia. They claim the report's undetermined manner of death was not emphasised to the grand jury, and this potentially skews their view. But this detail again remains unverified due to the limited public access to grand jury records. Let's just take a pause there. Should investigators with personal connections to a witness be allowed to lead a case? Tap the like button if you think that's a conflict of interest, or comment if you disagree. One major point of contention is the Google searches for how long to die in the cold, allegedly made by Jennifer McCabe. The defence say it happened around 2:30 a.m. before O'Keefe was found, suggesting someone else knew he was outside. Prosecutors claim that the search occurred hours later, after his body was discovered. The timing here is crucial. We need to know the right answer. If you could ask an investigator one question about this search, what would it be? Let us know in the comments section below. Here at Law and People, we believe every case tests the justice system ability to balance evidence and fairness. The Karen Read case raises questions about how we weigh circumstantial evidence, handle conflicts of interest, and ensure transparency. The real question here is, what does this case say about trust in our legal process? We'll keep following the Karen Read case as it unfolds. And if you're passionate about justice and accountability, hit the subscribe and join our community. We cover cases that challenge how law and fairness intersects, and your voice matters. So stay tuned for our next deep dive into law, mental health, and justice. Until then, keep asking questions and keep seeking truth.